Hi, and welcome back to Mama to Two Howeries. Today, it is going to be a day that we all will learn what objection hearsay means so that we can know what it is all about and be more informed than Elaine or Amber in the hearsay matters. So let's get into it. Okay, according to the Federal Rules of Evidence 801, hearsay is a statement that the declarant does not make while testifying at the current trial or hearing. The party can't offer that statement into evidence to prove the truth of the matter asserted in the statement. For example, if we have Sarah versus Bob, Sarah has an out-of-court statement that she told her counselor saying that Bob punched her, and the counselor writes this statement down. Sarah's lawyers can't put in the counselor's note of that statement because the counselor can't be cross-examined about the incident reported to her because she has no first-hand knowledge on the actual incident. Now, the counselor could come in and testify themselves and say, yes, I took these notes. Yes, that's what she told me. And then if she's asked, by Bob's team, if the counselor saw a bruise, the counselor could say yes or no, because that's something that she observed and would have seen, and that would not be a self-reporting statement. So that's a way to sometimes get that stuff verified. We did not have that in Depp v. Heard. The notes from her therapist did not come in, nor did that therapist get called to testify. So those did not come in, and they were all self-reported notes from the therapist. So that is a part of why they did not come in. Admission statements by party opponent. So the prosecution or plaintiff can introduce hearsay statements made by the defendant and introduce that the defendant confessed or said something in regards to the illegal or libel action. Same thing would be the defendants can introduce statements by the plaintiff that the plaintiff admitted to, or statements made in regards to the illegal libel action. You just cannot enter your own party's statements. It has to be the party opponent that introduces those statements. Defendants in out-of-court testimony. The defendant is not allowed, under the rules, to introduce their own out-of-court statements. That is kind of what we were saying above. The rules view this as self-serving hearsay, and clearly it doesn't fall under the party opponent exception. Therefore, the defendant can't introduce their own out-of-court statements. Moral of this story, remember, anything you say can and will be used against you. If the defendant talks and it's against him, it's allowed. But if the defendant talks and it favors him, it's not allowed. Same thing with the plaintiff. If the plaintiff talks and it's against him, it's allowed. If the plaintiff talks and it favors them, it's not allowed. So it can be used against you. And that is kind of what that means. You can't come in and say, see, I said this. This backs me up. You can't do that. You don't get to just stack the same thing upon the same thing upon the same thing. You're there to testify. We have it. We don't need your out-of-court statements about what you think or what you say happened, because we have you live and in person. So, example, Sarah versus Bob. Bob's lawyer can bring in defendant's out-of-court statement to show inconsistent statements. Nothing that is self-serving can be entered by Sarah's lawyer in this instance. So if Sarah said in a police report or deposition in trial, it says something other than what she testified to, this hearsay is admissible. And it's admissible by your party opponent to show that you said this before, now you're saying this. The two statements don't match, so which one is it, basically? And so by doing that, it lowers your credibility if you have a different statement about the same incidents. However, if it is an observation made by police in the report that they saw a bruise and it wasn't Sarah just reporting it, it can be verified and that can come in. So they could call the officer and say, did you see any bruises? And he could say yes or no, because it's his observation. It's not Sarah just saying, I had a bruise. If that makes sense. So that is how that kind of stuff can be introduced. But again, Sarah's lawyers cannot bring this stuff in. They could call the police officer as a witness and ask if he saw this. And if this is what he observed happened. Okay, so we're going to be moving on now. Not hearsay statements. To argue that an out-of-court statement is not hearsay, you must show that the statement is not being introduced to prove its truth. There are a number of other examples and ways to show that a statement is not hearsay, but the general point remains the same. Where the statement is not being offered to prove the truth, it is allowed so long as the judge agrees. The rule makers felt that in certain instances, an out-of-court statement is reliable and will allow these statements admissible under limited circumstances, which we will be going over later what some of those are. Hearsay statements made by a defendant. These statements are allowed where 1, admission or statement by party opponent, or 2, the plaintiff may wish to offer the statement to show the defendant made false representation to the authorities from which the jury could infer consciousness of guilt or liability. Note, only the first one is a hearsay exception. The second one is not considered hearsay at all, so hence not an exception. So example, Sarah makes a statement that says there is marble floors. It is hearsay, but since it isn't offered for the truth of the matter, it doesn't make it what it is made of is not. So what the floors are made out of has nothing to do with, in our examples, instances between Sarah and Bob. So it can be said. Okay, let's move on. This is Rule 2608, impeachment by evidence of reputation for truth-telling and conduct of witness. A, reputation evidence of a character trait for truthfulness or untruthfulness, which is the credibility of a witness, may be attacked or supported by the evidence in form of reputation subject to these limitations. The evidence may relate only to character trait for truthfulness or untruthfulness. Evidence of a truthful character is admissible only after the character trait of the witness for truthfulness has been attacked by reputation evidence or otherwise, and 3, evidence is introduced that the person testifying has sufficient familiarity with the reputation to make testimony probative. B, specific instances of conduct, extrinsic proof, except as otherwise provided in the rule by other principles of evidence or by statute. One specific instance of conduct of a witness may not be used to attack or support credibility, and specific instances of conduct of a witness may not be proved by extrinsic evidence. C, cross-examination of a character witness. Specific instances of conduct may, if probative of truthfulness or untruthfulness, be inquired into a cross-examination of a character witness concerning the character trait for truthfulness or untruthfulness of another witness as to whose character trait the witness being cross-examined has testified. D, unadjudicated perjury. If the trial judge makes a threshold determination that a reasonable possibility of falsity exists, any witness may be questioned about prior specific instances of unadjudicated perjury. Extrinsic proof of unadjudicated perjury may not be shown. E, prior false accusations in an SA case, except as otherwise provided by another evidentiary principles, statutes, or rules of court. A complaining witness in an SA case may be cross-examined about prior false accusations of a specific type of misconduct. I will not say those words because YouTube does not like those words. So these are different things that can be done, and you can impeach them with statements that can work to the credibility of whether things are truthful or untruthful. All right. These are the exceptions, which is going to be under Federal Rules of Evidence, Rule 803, exceptions to the rule against hearsay. And I'm going to list some of these. There are other exceptions, which is number 17 down at the bottom. And you could also go to Rule 807 or Rule 602 to look at other things about things. I will also have the link in the description where I got these from, and you can look at further details of explanations of some of this stuff. Okay, so number 1, present sense impression. So something that is present and is being done at the time, not at a later date. So saying something to your therapist or your counselor at a session after the incident is not going to be present tense. So it is not an exception to the rule because it is past tense. 2, excited utterance, which is kind of like being stressed, shocked, all these different things. Those are exceptions. 3, then existing mental, emotional, or physical condition. 4, statements made for medical diagnosis or treatment. That is going to be by a doctor, not a counselor, not a therapist. 5, recorded recollection, including family records, records of or absent of regular conducted activity, public records, vital statistics, or absence of public records, certificates of marriage, baptism, and similar ceremonies, records and statements in documents that affect an interest in property, statements in ancient documents, market reports and similar commercial publications, statements in learned treaties, periodicals, or pamphlets, reputation concerning boundaries, personal or general / family history, including character or previous convictions. Lastly, judgments involving personal, family, or general history or a boundary. So many of these things have to be like official type records that are kept. Some of these are like court documents, official documents that can be found, and they are done through other people that are not going to be prejudicial. It's just going to be there to state that this is what is what. And I am sorry, I have some of this numbered wrong, but that is okay. We'll just deal with it because I combined some of these so that the list could be shorter and I could fit all of them on this one slide. But as I said, you can look at other exceptions and more of a description of these exceptions through the link that I provide in the description box. And to the last slide. What is hearsay within hearsay? Because you hear this stuff sometimes, especially kind of in the Depp v. Heard case, that's hearsay within hearsay, and sometimes within hearsay. So it's like a double hearsay or a triple hearsay. Hopefully it doesn't go on with that, because it shouldn't be coming in on just one hearsay. So for it to be twice, 3 times, 4 times removed hearsay, that stuff cannot come in. One of the examples is Elaine keeps bringing up a text from Stephen Deuters that was sent to Amber saying, "When I told him he kicked you, he cried." So that is Stephen Deuters saying that he told Johnny, and then Johnny told him, and then now Stephen Deuters is telling Amber. So that's a lot of hearsay. And then sometimes, like with the counselor or the therapist notes, is going to be from Amber to the therapist to her notes, and the notes to the court, which is what Elaine and Amber want. And there's a lot of other questions about these notes. Originally, abuse started in 2013. Then, miraculously, she remembered after 4 years of saying this, it was in 2013. She could never forget it, because you never forget your first time. Comes back and says, oh, wait, it was 2012. Now, with these therapist notes that are being taken contemporaneously, they start in 2011. And the discrepancy is it early 2011 or is it late 2011? Because they were not together for most of 2011. So the time of the first event and when all this happened, there's just a lot of things that are just unclear. And so that is part of the reason as well that these therapy notes did not get brought in, on top of the fact that they are hearsay within hearsay. But let's go into what the definition of this is. According to Federal Rule of Evidence, Rule 805, when proposed evidence is hearsay and it contains other out-of-court testimony within it, this is hearsay within hearsay, or double hearsay. It is not excluded if each of the combined statements conforms with an exception to the hearsay rule. Hearsay within hearsay is not excluded by the rule against hearsay if each part of the combined statement conforms with an exception to the rule. And in regards to Sarah and Bob's examples we've used, and in Depp v. Heard with the therapist notes, those are going to be hearsay within hearsay, and they do not fall into any of those exceptions that we talked about prior to. So let me know below Do you think that therapist notes should come in? Or do you think that they were just hearsay and we don't need the therapist notes to tell us what happened because we have her on the stand telling us what happens? So we don't need double testimony, basically. Also, if you have any other questions about hearsay, let me know and I will get those answered for y'all. Until next time, I will see y'all later. Bye.